But I do have a presentation to talk to you about the delinquent tax purchasing process in Kentucky, and I've kind of had it in three broad sections. First, kind of from a historical perspective, how did we get to where we are today? Then the second section is the Ken Perry section. He's already taken that from me, so we'll probably skip through go through some of those slides pretty quickly, and then wrapping up the impacts that the third-party purchasers have had in Kentucky, and it's not just fiscal. And there had been some references to that already this morning. So Stephen's been replaced on the PowerPoint by my assistant director, Melissa Klink. That's Melissa. She's learning this process, and that's why she's here today. But she's also very good at clicking on the PowerPoint, and she created this, so go ahead. Okay, so first of all, how did we get here? Back in the, as an earlier slide said, that there's been isolated property tax purchases for decades, and that is the case in Kentucky. Except for 1985, I think it went to like 1995. We had very, very isolated purchases of tax bills at the sheriff's offices at that time. So the sheriffs did conduct the sales. Most of the times they went out on the courthouse steps and offered the tax bills to nobody. Nobody was buying a tax bill. But then in the mid-1990s, the Jefferson County Sheriff's Office, Jim O'Daniels is now, he's the controller, or was the controller in the sheriff's office. He called me just excited as could be because some third-party purchaser had shown up at his tax sale and bought virtually every single tax bill that Jefferson County offered. And he, of course, Jim's thrilled because he's all about the money. The sheriff's going to get all these new commissions, that type of thing. This is great. And I said, well, Jim, that's great. That's wonderful news. Well, a year rolls around, the tolling period for the delinquent tax bills, and the county attorney saying, all of a sudden wakes up and realizes, hey, I don't have anything to collect from this tax year. And of course, the county attorney, we're a fee-based state for these local officials. They all add their fees, as you all well know. Well, the county attorney has no fees to add to these delinquent tax bills. That's, hundreds of thousands or millions of dollars in Jefferson County. So, what does that lead to in Kentucky? We have legislation that changes the way tax bills are going to be sold. So, House Bill 568, this was done under the Patton administration. I actually worked with the current presumptive nominee for governor on the Democratic side anyway on this legislation. Anyway, I don't need to drop names, do I? But anyway, this legislation said if the total of all offers received from third-party purchasers exceeded 10% of the total amount due, or $200,000, whichever is less, that $200,000 is in effect for Jefferson County only, then the sheriff would have to notify the finance cabinet within 5 business days. The finance cabinet would then have 15 business days to complete the purchase of all the tax bills upon which an offer was received from a third-party purchaser. And that way, we would then preserve those fees, for the most part, for those local officials. We would let the third-party purchaser have up to 10% of them, but then all the rest of them would go through the normal process. So, and the state was officially, the finance cabinet was the owner of those delinquent tax bills, but we utilized the county attorney to enforce collection. The county clerk made the accepted payments on our behalf and things of that nature, but the whole amount would come to the finance cabinet. So that worked fairly well for a number of years. For the most part, third-party purchasers kept their offers below those thresholds, and we limped along for 3 or 4 or 5 years. But then, okay, just to give you an example of what we did have to do at a time or two, for some reason, Fayette County and Kenton County were our trouble spots. And just, as an example, this will become more apparent as to why this is important in just a few minutes. But in Kenton County for 1999, there was a total of 678,000 plus in delinquent property tax bills. The offers were 267,000, so obviously that exceeds the 10% threshold. So the finance cabinet had to step in, and when all of a sudden we're the owners of a little more than $250,000 of delinquent tax bills. Same thing happened in Fayette County, only it was to the tune of about $1 million. So anyway, and I'll show you why that's important in just a few minutes. Go ahead, you can go ahead. Then, so we limped along for a few years, but then there's the flag drilling court case in 2003. And this allowed people that had bought delinquent property tax bills to also recover. It was specifically allowed to recover. They were allowed to recover their attorney's fees. And that court case ruling was issued by the Court of Appeals in January of 2005. So, obviously that increased the interest again in the delinquent tax bills. So in 2006, we'd intervened in a couple of counties in those 3 or 4 years prior total. But now in 2006, we purchased bills in 5 counties. In 2007, it's up to 16 counties that we had to intervene in. 2008, we're in 40 counties. And you're still thinking, well, okay, you're forcing the finance cabinet to buy a lot of tax bills, but what's the point of all this? Well, attached to that legislation that was enacted that set those thresholds, there's also a $25 million cap that the finance cabinet could invest in delinquent property tax bills. So every time we had to intervene in those sales, we're inching closer and closer and closer to that $25 million cap. And in fact, we had to let some 2007 delinquent tax bills in Jefferson County go to the third-party purchasers because we didn't legally have the authority to buy those bills because we had hit the $25 million. Also, those purchases were causing mass confusion out in the sheriff's office. Remember, most of these sheriffs had never sold a tax bill before. They've been sheriff for 20, 30 years. And now all of a sudden they have these third-party purchasers on their courthouse door asking to buy bills or submitting offers to purchase, and the sheriffs are going crazy. They don't know what to do. So that was the second impact. And then, of course, we had a lot of record keeping going on, trying to figure out, okay, we bought $1 million here, $500,000 here, 200,000 here, but we've had some redemptions since then. How much can we afford to buy? Can we still buy Jefferson County's tax bills, for instance, legally buy those? So all of those factors led to the situation where we just decided we've got to overhaul this system. It's broken again. We just can't do this anymore. And that led to the overhaul known as House Bill 262 that was enacted in the 2009 session of the General Assembly. So how did we get there? And I wish Commissioner Miller was here. I was going to give him some props because he authorized me to start doing this. We had the idea early in 2008, but the commissioner at that time was on board, but then he resigned. And so we weren't sure if we were going to be able to do this or not. When did Tom become commissioner? Was it June or July?
Been 8 years, so I think
it was the summer.
June or July.
June or July of 2008. He didn't know me from Adam, but I'm up in his office on the 11th floor of the state office building saying, you don't really know me, but we have this idea. Here's the problem. I'd like to have a solution, and he green lighted it from day one. So be sure to tell him I gave him good words, okay, if you see him. But anyway, we were able to come up with a working group of county clerks, sheriffs, county attorneys, PVAs. We had legislative research commissions, and then towards the end we had Ken and other third-party purchasers participating as well. A good working group to try to come up with some sort of solution. And we had lots and lots of meetings, lots and lots of phone calls, emails, so on. We got Representative Arnold Simpson, as Ken mentioned earlier this morning, to guide us through the process. We had CACO, Kentucky Association of Counties. We had the various associations of PVAs, clerks, county attorneys, all that good stuff. All those came together, and we convinced in a short session, by the way, of the General Assembly for this overhaul to get passed in the 2009 session. So what did this do? It transferred the delinquent property tax sales from the sheriffs to the county clerks. The sheriffs will tell you, and I've told them, they were the big winners in this. They got rid of all the tax sale duties. They got to add their fees and commissions to the total amount that was transferred to the county clerks. So they're still getting paid everything they would have gotten paid had it been paid to the sheriff's office in the first place. But yet they don't have to do any tax sales work or anything like that. So they were the big winners. Again, the way county clerk offices, county attorney offices are funded, it's through these fees. So this solution protected the fees that were going to be earned by the various players at the local level. It did establish some specific procedures that the county clerks are supposed to follow when conducting their tax sales. And then it did impose some new requirements on all of your third-party purchasers with regard to registering at both the state and the local levels. You also have specific information to put in the notices. We talked about how many times they get noticed in Kentucky, and there is specific information that you have to include in those notices now. And then we do review your, I think, business practices. That means we ask if you're current with all state taxes on your application, that type of thing. So that was in 2009. The ink was just barely dry from the governor's signature. And then I think I got a call from Jerry saying, what about oil and gas tax bills? Maybe somebody called me real soon. We're going to give you credit for that. And I was under the impression that we shouldn't sell oil and gas or unmined minerals tax bills because that information comes to us on an actual tax return. And I was under the impression again that there were some confidentiality issues, and that's why we didn't want to have those included in the tax sale. Well, I found out there was going to be a workaround to that scenario. So we come back to the General Assembly in the following year, and again, we now allow oil and gas and unmined mineral delinquent property tax bills to be sold to third-party purchasers as well. In 2012, we came back again with some for some installment payment plan, specific information or guidance on that. Most of you were probably already offering payment plans anyway, but now there's some specific guidance in the statute about that. And it also allowed the county's initial delinquent property tax list to be posted to the Department of Revenue, and that's a compromise that the Commissioner alluded to with the Kentucky Bankers Association earlier this morning. Okay, so now we get to the Ken Perry part of the presentation. He's already I think he looked at my slides, or somehow he got them, and used some of them himself. So we can go through these pretty quick, but the third-party purchasers who plan to purchase more than 3 certificates of delinquency in a county, or more than 5 statewide, or if you want to invest at least $10,000. Maybe, as Ken said, you want to find that $100,000 tax bill. Even though you're just buying one bill, because it's so large, you do have to register with the Department of Revenue. That registration is done on an annual basis. It covers a calendar year, and it does become effective 60 days from the date I receive it in our office. We do open the registration process in October of each year, so that if you want to get ready to go or keep going January the 1st of the following year, you can send your application in to us in October. You've met your 60-day waiting period. You're ready to go January 1 the following year. And the registration fee, as Ken said, is $250, and that is an annual fee. Now, that was the state registration. Now there's also a local registration for every tax sale that you want to appear at in a county clerk's office. And the county clerk has registration forms. We have provided samples, but I'm sure county clerks have doctored those up to suit their own individual needs. But it does require you to have your contact information, and there is a section that you're going to affirm that you're not participating with any related parties at the tax sale. With that registration form, you can have up 2 separate lists of bills. One is the priority list, that you already have a priority on this particular current year tax bill because you bought that same bill on that same bill on that same property in a previous year. So you have first shot at that bill for the current year. That's one list. The next list is and the full amount due on that priority list would be due at the time of registration. The second list, again, are the bills that you're interested in acquiring at the tax sale. And there's a 25% deposit that's due with that list. And again, a registration fee of $5 per bill shown on your priority list and $10 per bill on your other list, up to a maximum of $250 is charged by the county clerk. Now, on the day of the tax sale, the county clerk will first allocate the priority bills to the appropriate third-party purchasers. And then the third-party purchasers draw for their selection order by round for the actual tax sale. And there are, in regulation, there are all these requirements. If you have up to 500 or fewer tax bills to be sold, then the clerk can do up to 5 bills per turn, and so on and so forth. Now, I've been hearing that county clerks have realized that it's just much more effective and efficient to go one by one for the first 2 or 3 or 4 rounds, or maybe the whole sale. Is that your experience? Yes?
Some exceptions.
With some exceptions, and I've tried to work with a couple of those exceptions as well, but I'm not sure how successful I am. But I'm sorry? Yes, I agree, especially in this time of where you're not having maybe as many delinquencies available to purchase. I think you should go one by one in the first round or 2 at least. So we don't need to, but those are in regulation as to the amounts that they can sell per round, depending on the number of bills that are available for sale. Now again, you're eligible to select only those certificates that are included on your list that were submitted with your registration. I think a lot of you are just using the county clerk's latest delinquent property tax bill list so that you're eligible to buy any tax bill, and that makes sense to me. You can withdraw from a tax sale at any time, but nobody else can take your place. Nobody else is going to get 2 chances during a round if somebody else withdraws. Now, do you see many county clerks imposing time limits? I did go to one sale where the county clerk had like a minute or so time limit. And 60 seconds is a long time. It really is when you're waiting for someone to make a selection. Of course, he was also letting them go up to 5. And then after the first round or 2, they're starting to struggle, and they're really starting to go through their list, and everybody's just kind of sitting there and thinking, man, there's got to be a better way. And there is a better way. Just do it one at a time and that type of thing. But they can impose a time limit if they want to. The county clerk applies the purchaser's deposit towards the sale, and if any additional amount is due, then the third-party purchaser remits the funds in a manner required by the county clerk's office. And then there's also a lien recording fee that must be paid in addition to the total paid for their certificates. Now, when we first started, you can go ahead to the next slide. Several third-party purchasers offered to pay the lien release fee in advance, and county clerks, a number of them took them up on that offer. They were always looking for another fee, and they'll think, well, let's take that. I think it's $13 to release the fee, if I'm not mistaken. They got the $13 up front, so they're paying a $28 lien recording fee and a $13 lien release fee. But we've told them, our advice to the county clerks at first we were kind of ignoring the situation. We really didn't care. But now, the last 2 or 3 years when I go before the county clerks, our advice is not to take that lien release fee until the bill's actually paid. And I don't know how many of you still do offer to pay that up front. I don't know, or maybe that's not a practice anymore, but that did happen. I had several phone calls in the early years about that practice. This is probably more and more common. If the amount of the deposit exceeds the amount that you paid for your certificates of delinquency, the county clerk must refund the difference within 10 business days after the close of the tax sale. And I'm sure that's a very common practice now. Okay. Now, properly registered third-party purchasers can acquire a bill at any time that their registration is in effect. You don't have to just go to the property tax sales that are conducted by the county clerks. Right now, you can purchase 2013 or earlier tax bills in any county clerk's office at any time. Now, they will charge you a $10 quote-unquote registration fee, but that does get applied to the $250 maximum. So if you bought 25 bills already this year, when you go to the tax sale, there's no more registration fee to pay. Okay? After this year's tax sales are done in the summer, you can, if there's any 2014 bills left over, you can certainly go into the county clerk's office and purchase those at any time. And again, if you haven't met the $250 registration maximum, there would be a $10 registration fee paid. Okay? All right, refunds to third-party purchasers. There is a statute that governs the refunds to these two third-party purchasers, and there are very specific reasons why a refund would be made. And we have counseled PVAs, property valuation administrators, over and over, and I think we're getting better. I hope we are getting better. But sometimes they would issue an exoneration or getting rid of the tax assessment for just really because it was a local taxpayer who was complaining loud enough, possibly, about having to deal with a third party, and they would come up with some reason. Oh, well, I messed up your address somehow. I didn't put a period in there or something like that. Maybe not quite that bad, but it was not a very good reason for the assessment to be exonerated by the property valuation administrator, but yet they were striking them out. The refund was made to a third party. You all were out your additional fees, and then the taxpayer, lo and behold, had a chance to pay a lower amount at the local level. Well, again, I think we're doing better. I hope we're doing better, but we have had several conversations at PVA conferences and also several direct one-on-one conversations with particularly offensive property valuation administrators about that practice. So, but that is a reason. If the PVA exonerates a tax bill or otherwise determines that it was not subject to taxation, that is a reason for a refund to a third-party purchaser. If the certificate should not have been sold in the first place, since it met the requirements to being on the county attorney's quote-unquote protected list, that would be another reason. And on the next slide, there's the reasons to be eligible for inclusion on the county attorney's protected list. If there's a payment plan in effect with the county attorney that's current at the time of the tax sale, that bill should not be sold by the county clerk. If it's involved in litigation initiated by the county attorney or in which the county attorney responds or files an answer. And finally, if it's involved in bankruptcy litigation in which the county attorney has filed a claim, those bills should be on a list provided to the county clerk about 10 days prior to the tax sale, and those bills were not eligible to be sold. Now, most county officials, county clerks, will go on and process the refund and issue it to a third party. There might be some that wait for you all to apply. And the statute does say that a third party purchaser should apply for a refund, but most of the time you don't even realize that's going on, or maybe it's well after the fact. But a lot of county clerks have told me they go ahead and process a refund and send it to you. And maybe with a letter of explanation, I don't know. I advise them to do that, but I don't know if that's happening or not. Okay. Now, if the county clerk does not have sufficient funds to issue the refund, there are a couple of options. They can just retain the claim, and then once they do get sufficient funds to make the refund, then they will do it themselves. Or they can write a letter to the third party that details the amount that's due from each individual taxing district, including the state portion that would come to us, and it also directs each taxing jurisdiction or fee official to refund the appropriate amount due to the third party. So that you're going to get, instead of one check from the county clerk, you might get up to 7, 8, 9, 10 checks for each individual part of a refund. Has that happened to anybody? You, okay. And you back there. All right. Now, when a refund is made, the county clerk is authorized to go ahead and release the lien, and a copy of that lien release document is required to be provided to the third-party purchaser. Okay? Now, I'll wait for comments here. The amount refunded does not include the $28 lien recording fee. And the county clerks, they're a good lot. They are very powerful politically. They've got that specifically in the statute. So that the $28 is not refunded. It's part of their fee, and it's going to be retained by the county clerk's office. If a refund is denied by a county clerk or by the PVA, then you do have the option of going to the Kentucky Board of Tax Appeals. And I have heard here in the last 2 or 3 months, I know of a couple that are going to the KBTA. It'll be interesting to see how that works out. Because we have had this in place for a number, 4 or 5 years, and now I'm just now hearing about some sort of appeals going before the KBTA. Okay. All right, and then notice requirements. We talked about that a lot already today. The notice must be sent by the third party within 50 days after the delivery of a certificate of delinquency by the county clerk to the third party purchaser. And there's the specific information that included in the statute that the notice must contain. A statement that the certificate is a lien against the property, that it bears interest at 12%, and so on and so forth, the total amount due, and that type of thing. Okay? And then, as Ken alluded to, you do work with PVAs to try to obtain updated address information. If the delinquency is for an oil and gas or unmined mineral bill, though, those assessments are made in Frankfort by another division of our department. Greg is the director of that area. And he and his assistant director and maybe another branch manager, I guess, work with several third-party purchasers or their representatives in obtaining addresses or updated address in those areas. So those would be directed to Frankfort, to the Department of Revenue. Okay. Our involvement with the various players in this whole process. We'll start with the county clerks. So we have had many training sessions with county clerks at their various conferences. We've had regional meetings. We've had I have gone to clerk offices for one-on-one training. So I hope I think they're slowly getting comfortable with the process, but there's always going to be some variation between counties. You all know that. But hopefully our goal is to be that every participant at that county is going to be treated fairly. County A may do this, County B may do this, but hopefully they're being consistent with all participants in their tax sale. It's no secret that many county clerks do not like third-party purchasers or did not like third-party purchasers. It's not a secret at all. Fayette County, Linda Potter in Fayette County will openly admit, and she even told me to tell you all that she still doesn't like third-party purchasers. Jefferson County was very welcome. Hardin County was very open to third-party purchasers. I think we're winning converts over there are seeing the positive impact that third-party purchasers can have. So I know, I'll call it. I remember going and Laurel County clerk. He just raked me over the coals about this whole process. He stood up in front of 250 people, and I'm just standing here going, okay, this is great. But, afterwards we had a private conversation with him, and he's now a believer in third-party purchasers. Maybe he doesn't really welcome you with open arms, but he understands the process. So we're slowly winning over some converts to this process. Okay? Now, we also work with the delinquent taxpayers. I, from time to time, get calls from people, and the biggest complaint, they're asking about the various fees that are added. I provide them with the statute about the fees. I do, on occasion, review billing statements, and I have had 1 or 2 where the third party did make a mistake, and they even said, I see it. It was cleared up very quickly to their credit, but for the most part, I might review it just because I need to get them off the phone, and I'll tell them I will review it. But you all are doing a great job following the statute, calculating things correctly, and I just have to tell them, I'm sorry. Yes, it's expensive, but that's part of the deal. You need to pay this off. Call them up and get a payment plan. Pay it off. So I do review them, but very, very, very rarely will an adjustment has ever been made. And I do provide updated contact information from time to time that maybe the county clerk does not have. Okay, and then of course I do work with you guys. We try to keep the website updated regularly with tax sale date information. The delinquent property tax bill lists are going up. This is the time of year we have till June the 1st to get the 2014 tax bill list on our website and the county clerk tax sale dates. We have links to all the various statutes and regulations. There's a manual out there for all potential third-party purchasers. Ken had a nice little slide about what you should consider before you get involved in this. And if you do want to take the step, then I have a little primer on here's what you need to do to be a third-party purchaser. And I don't want to make Greg nervous because I try not to practice law without a license, but I do provide some guidance to some, especially the smaller third-party purchasers, but I try not to give them any legal advice, Greg, so I don't want to make you squirming in your seat or anything like that. Okay. The most common complaint, of course, is with regard to the amount of the fees that are added to the tax bill. And again, I just have to tell them, I'm sorry, that's the way it is. But as Ken mentioned, you need to maintain documentation on the attorney's fees that are incurred, both the pre-litigation fees and then after a foreclosure proceeding has been filed. It's $175 up to $175 increments for fees that are incurred can be added, but you have to do it no more frequently than on a quarterly basis, and then you have to send another notice as well. Okay. Post-litigation attorney's fees of up to $2,000 may be reasonable if requirements in the statutes are met, and there are very specific work how the work is done, if it's billed within at a reasonable rate, and that type of thing. And then the court would have to prove anything above up to $2,000. And I'm always open to getting feedback from you guys as to what is reasonable for a title search or whatever else. I don't know, but I'll get a call from a taxpayer saying they're charging me $500 for this. It shouldn't be $500. And I don't have any idea. I don't know. So if you all want to send me something, an email or phone call or what have you, or today, I'm willing to listen to you about what's reasonable on post-litigation fees. Okay. Another common complaint is the inability to make contact with third-party purchasers. Well, there's 120 county officials that I deal with with clerks or county attorneys, that type of thing. There's probably one or two PVAs or clerks or whatever that I really dread dealing with. But out of 120, that's not too bad of a percentage. Well, coincidentally, there's about 120 people that are third-party purchasers that are registered with the Department of Revenue each year. I'll show you specifics later. There's probably one or two or three that cause the most phone calls, emails, headaches for me. And that's not a bad percentage. So I don't know really what my point is, but they just need to keep their contact information up to date, or I wish they would just answer the phone and talk to the delinquent taxpayer. But for the vast majority of you, it's not an issue. There are most of you, all I hear from you every year is when you send in your application, your $250 check, we process it, issue your certificate of registration, and I don't hear from you all until the next year when you're ready to do it again. And that's the way I'd like it, and I'm sure that's the way you all like it too. Because that means you're doing your due diligence, you're responding to the taxpayers, and you're doing things right, and that's the way it ought to be. But again, just make sure your current contact information is included in the notices, and this is one of the kind of the bad actors. I have actually called a third-party purchaser's phone number and got told that his voice mailbox was no longer accepting messages and that type of thing. So I'm just wondering, how is that taxpayer supposed to get hold of them? So again, that's just a very small percentage. And another issue that's going to be confronting you guys. Please be patient with the 31 new county clerks that just took office this past January. We've had them in a special training session just for this purpose. I've been to their conferences as well, just for this purpose. But again, it's going to be their first tax sale for these 31. So just be patient with them. And hopefully they'll get through it and they'll get comfortable and everything will be just fine. But if there's a problem, please let me know and we'll try to address it. Okay, impact of third-party purchasers in Kentucky. Increased voluntary compliance by taxpayers. Kind of a good unintended consequence. People don't like to deal with third-party purchasers, do they? I mean, these delinquent taxpayers. We have a good collection percentage statewide. It runs around 98%. But there are always some property owners, and even the county clerks that maybe don't welcome third-party purchasers will tell you that there are always somebody in the county that seems to just choose not to pay their tax bill. Then that taxpayer has their bill purchased by a third party, and they have to deal with a third-party purchaser, and lo and behold, the next year, they pay their taxes. So that's a good thing as far as we're concerned, and probably from you all too. But so there has been some very good anecdotal evidence that there is increased voluntary compliance because of the impact of third-party purchasers. Okay. Another one, I alluded to this one earlier about PVAs just starting to exonerate tax assessments because, I've got this long-time property owner in my county who has a lot of family members, and I need to take care of them. Well, it's also spurred them to improve their property records in the first place. They have better maps. And we are also helping to try to help that process. We have technology, improved technology, and we have people working in those counties every day. But this has also been a good factor for the PVA to take the initiative to improve their records and get things straight so they don't have those mistakes, so that leads to a delinquent property tax bill. And then, of course, finally, the fiscal impact. Tom alluded to this earlier, but in 2009, you all went crazy. You all bought, and this is just at county clerk's tax sales. This is not any reflection of bills that you buy outside of the tax sales, because I don't want to go through all these county clerk records for a whole year. I'm just looking at the ones that pertain to a tax sale. But you purchased about 26,000 tax bills from the year 2009. That would have been in the calendar year 2010. In 2010 tax bills is down to 16,000. And then a slow trend down, but for the past 5 years, 84,426 bills just at tax sales have been purchased by third-party purchasers. Now, for those 2009 tax bills, I just pulled out a few select impacts. At the state level, we had almost $2.5 million. The schools are the biggest recipients in property tax revenues. They received almost $10.5 million. For the county clerks, even though some of them don't welcome third-party purchasers, well, they cashed your checks in the amount of $2.7 million in that year. Okay, the grand total that was spent was The grand total it was almost $32 million just for that year at tax sales. The next year, 25.5, 21.5, 18.9, and then 16.6, a grand total of $114.5 million in total has been spent by third-party purchasers just at tax sales. I don't know how many other thousands of bills or millions of dollars you've spent outside of the tax sales. Okay, this is just a beginning point, a starting point for what the fiscal impact is by third-party purchasers. Okay, number of third-party purchasers, as Tom said, we started off, 2010 was the first year we had registered third-party purchasers, and we had 77. Then it shot up to 125, down a little bit to 122, down a little further to 114, but now we're back up last year. And when I made this slide, we had about 90, but I think we're pushing 100 now that are in my office or Greg's office for review. We're right at about 100 because by this Friday, if you want to be eligible for all of the tax sales that start in July, I believe it's this Friday is the deadline to get your application in. And that's why we're having a big flurry of applications being received this week and last week. Okay? So there's my contact information, and there's Melissa's contact information. She is learning all about this, so feel free to give her a call as well or an email. But now I guess it's time for the panel, I guess, to answer any questions or listen to any comments you have.